I'm a mom of a 13-year-old. It pissed me off. He's a piece of dude.
Defendant is an unauthorized alien.
It feels like a never-ending nightmare.
What you did was purely evil. It's sentence for your crimes, life without the possibility of parole.
In August 2025, tragedy struck on the Florida Turnpike when truck driver Harjinder Singh attempted illegal U-turn with his tractor trailer in St. Lucie County. A minivan collided with the trailer, killing 3 people. Investigators later revealed Singh had entered the U.S. illegally in 2018 and had obtained a commercial license despite failing basic language and traffic sign tests. After the crash, he fled to California, where authorities arrested him. His brother, who had been in the truck at the time, was also taken into custody by immigration officials. The case quickly drew national attention, sparking debates over immigration policies and licensing standards for commercial drivers. Singh was extradited to Florida and initially charged with 3 counts of vehicular homicide, later increased to include 3 manslaughter charges,
Where the court found vehicular homicide qualifies as a forcible felony. This court further finds that based on review of the sworn complaint affidavits, there is proof by preponderance of the evidence that the defendant is an unauthorized alien. Therefore, sir, I'm setting your bond on each charge at no bond.
During his first court appearance, Judge Lawrence Sweet denied bond, declaring him a flight risk and noting evidence of his unauthorized status in the U.S.
This was avoidable. This should have never happened. We're going to hold this guy accountable, 100% criminal charges, and he's going to be in prison for a long time.
I hope and pray that California gets their stuff together and the voters are listening, where your governor, your leadership cares more about American citizens and Californian citizens rather than making laws that support illegal immigration, that put people's lives at risk.
Florida Governor Ron DeSantis criticized California for granting Singh a license and sent Lieutenant Governor Jay Collins to oversee the extradition. The incident prompted federal authorities to tighten rules on issuing licenses to non-citizens, while Sikh groups organized vigils outside the jail calling for fair treatment. Singh now remains in St. Lucie County Jail as both state and federal investigations continue. In November 2022, 23-year-old Zaria McKeever was at her Brooklyn Park apartment when 2 teenagers, acting under the direction of her ex-boyfriend Eric Haynes, forced their way inside. The plan, prosecutors later said, was to target McKeever's new partner, but the situation took a tragic turn and McKeever lost her life. The case quickly drew widespread attention, not only because of the shocking circumstances, but also because of controversy surrounding plea offers to the suspects. In response, Governor Tim Walz reassigned the case to Attorney General Keith Ellison to ensure a stricter review and prosecution. By early 2024, Haynes admitted guilt to first-degree felony murder.
It feels like a never-ending nightmare.
In April, during Haynes' sentencing, McKeever's family described her as a devoted mother and daughter whose life was filled with love and potential.
It feels like a never-ending nightmare.
Instead of cherishing, protecting, and keeping her safe, he brought evil to her doorstep.
Haynes offered a brief apology, but her family said the words fell short.
I just want to say sorry to the family of Miss McKeever.
You give me more than those words. You owed us more than those words. And we didn't get it.
For them, knowing he will spend decades behind bars brought some relief and a step toward healing. The judge sentenced him to life in prison with the possibility of parole after 30 years. Others involved also faced justice. One of the boys received just over 10 years, while 2 others who helped after the crime were given shorter sentences. In 2021, 33-year-old Fanta Zayavong went missing after being in a relationship with Maplewood resident Joseph Stephen Jorgensen. 2 years later, in April 2023, 34-year-old Manije Mani Starin was also reported missing by her father. As police investigated Starin's disappearance, evidence led them to storage units linked to Jorgensen. There, they discovered the remains of both women, connecting him to both cases. In January 2025, Jorgensen pleaded guilty to 2 counts of second-degree murder, admitting responsibility for the deaths of Zayavong and Starin.
Every time I think about this, it still doesn't make sense to me. The punishment does not reflect the full gravity of what he did.
At Jorgensen's sentencing in February, family members of both women shared emotional statements, remembering Fanta as kind and selfless, and Mani as a loving mother who had dreamed of becoming a nurse.
Manny's children must now grow up without their mother who loved them more than anything.
Today we stand before you, overwhelmed with the pain and sorrow that words can barely convey. The loss of Fanta has left a void in our family and community that will never be filled.
Jorgensen also briefly apologized in court.
This is the most heinous, evil offense I have ever been a part of.
What you did was purely evil. The more appropriate sentence for your crimes would be life without the possibility of parole.
Judge Leonardo Castro described the crimes as among the most disturbing he had seen before sentencing Jorgensen to 40 years in prison, with credit for time already served. For the victims' families, the sentence served as only a partial measure of justice for the profound losses they endured. In April 2024, 40-year-old Lakeisha Timmons, a devoted mother of 8, was returning home after dropping her daughters and sons at school when she was confronted by her former partner, 53-year-old Ronald Fuller. Investigators later determined that Fuller had followed her for nearly half an hour before the incident. Surveillance footage and physical evidence placed him at the scene, and he was arrested soon afterward. A year later, in April 2025, Fuller entered a plea of no contest to second-degree reckless homicide, a reduction from the initial first-degree charge. On August 27, 2025, during the sentencing, Timmons' family spoke about the deep loss they continue to carry and their frustration at never receiving a clear explanation for what happened.
She should still be here. Her absence is loud. We have each other and we're going to get through it, but I feel like it is what it is today. I don't care for him.
They'll never bring my daughter back. I still wake up through the night waiting on her phone calls. I wake up every night waiting on her phone calls, knowing that she never coming back.
Fuller offered a short apology, but her loved ones said no words could match the void left behind. The judge sentenced him to 20 years in prison and 10 years of extended supervision, with credit for more than 500 days already served. In May 2024, police in Dayton were called to a home on Shaftesbury Road where they discovered Precious Taste and Deontay Johnson had lost their lives. Precious, who was pregnant, was remembered as a loving mother to her young twins. Investigators later identified Nicole Nico Cunigan Jr. as the suspect, pointing to surveillance video and witness accounts that placed him at the scene. At the time, Cunigan was already on parole for a prior case involving taste. The case went to trial in August 2025. Jurors heard testimony about what happened that day and how it affected both families. The prosecution argued that Cunigan's actions caused the deaths of Taste, her unborn, and Johnson, while the defense maintained he was not guilty. After deliberation, the jury convicted Cunigan on multiple charges, including murder and evidence tampering.
You took a beautiful soul. All the tough talk that you did, you wasn't tough enough to walk away. After she asked you to leave her alone, she just walked away, bro. No fish in the sea. You ended your life, hers. You didn't care about your kids. They say forgive and forget. I ain't gotta forgive you, I'm just gonna forget about you, bro. Cause that's what it is.
At sentencing, Precious's brother told the court their family had lost a beautiful soul and stressed that the tragedy could have been avoided.
I'm innocent. I just want to say I appreciate my family for the support, all my loved ones who got my back. I love my kids, they're gonna be took care of regardless of what happens. God don't put nobody through nothing they can't handle.
Cunigan continued to claim innocence while thanking his family for their support. The judge then imposed a sentence of 39 years to life in prison, closing a painful chapter for the victims' loved ones. In January 2023, 31-year-old Kyla O'Neill, who was just days away from giving birth, drove her fiancé, Dante McCrae, to the Amazon Fulfillment Center in Lakeville, Minnesota. The two had argued earlier that day, As O'Neill began to drive away from the parking lot, McCrae pulled out a weapon and fired, striking her. She was rushed to Hennepin County Medical Center, where doctors delivered her son, Messiah. Kyla did not survive her injuries, and her son passed away 9 days later. Investigators later revealed that McCrae first claimed the shooting was an accident, but surveillance footage contradicted his account. By October 2023, he pleaded guilty to 2 counts of second-degree murder, admitting responsibility for the deaths of both Kyla and her. In December 2023, during sentencing, O'Neill's family described her as the glue of their household and spoke of the devastation left behind.
And I honestly feel like jail is too good for you. She's no longer with us, so why should you still be able to breathe? You deserve everything that's happening today and what's coming your way. I hope that God have no mercy for your life. I know God is a forgiving God, but I'm not God, and I would never forgive you. You took my 9 months away from me, my 31 years with my baby away from me forever. Lonely as Kyla beside.
McCrae apologized in court, saying he would carry the weight of that day for the rest of his life. The judge sentenced him to 47 years in prison, with the 2 sentences ordered consecutively. In February 2022, 34-year-old Yulia Julia Lee, St. Paul business executive originally from Kazakhstan, was driving through the Payne Phelan neighborhood when she was caught in the middle of a drive-by shooting. She was on her way home from running errands when a stray struck her car, ending her life far too soon. Police later identified the shooter as Melvin "Dump" Williams. He admitted that he had been from a vehicle during a dispute with another teen, and that Lee was not the intended target. In 2023, Williams was certified to be tried as an adult and pleaded guilty to second-degree murder.
Came here for a better life. She came here for peace and prosperity. She deserved that, peace and prosperity.
At the sentencing in late 2023, Lee's family and colleagues remembered her as a bright leader, full of life and potential, whose loss left a lasting impact on everyone who knew her.
I'm deeply sorry and remorseful for that day. I offer my deepest condolences and prayers.
It's the exact reason that the legislature made drive-by shooting so serious, and in this case, an innocent bystander lost her life.
Williams expressed regret, calling the incident a true accident. The judge, however, stressed the seriousness of his actions and sentenced him to just over 32 years in prison. In August 2023, a backyard concert in South Minneapolis, known as Nudiland, ended in tragedy when shots were fired. The shooting claimed the life of 35-year-old musician August Nicholas Golden and left several others injured. The investigation led police to 2 suspects, including Dominic Burris, who was later certified to stand trial as an adult. In January 2025, Burris entered a guilty plea to aiding and abetting second-degree murder and aiding and abetting first-degree assault.
I'll let you guys know that I'm ready to be bettered and I'm willing to better myself.
2 months later, in March 2025, a Hennepin County judge sentenced him to more than 23 years in prison, with the assault charge running concurrently with the murder sentence. His co-defendant, Cyril Boyd, also reached a plea agreement, helping strengthen the case. For the victim's family and the community, the sentencing brought a measure of justice, though the pain of that night still lingers. In April 2023, 59-year-old Eric Bennett, who was unhoused, had been living in a culvert in Fresno when a fire broke out. Surveillance footage later showed Felicia Quiroz using a lighter to ignite the area, and investigators determined the fire was deliberately set. Bennett lost his life in the incident, and Quiroz was arrested several months later, facing charges of arson and murder. 2 years later, in 2025, the case reached sentencing in a Fresno County courtroom. During the emotional hearing, Eric's family members shared their grief, describing him as a man with humor, kindness, and a willingness to help others despite his own struggles.
He will never get to enjoy my grandkids or look forward to his. He will never be able to make memories with his son. He loved making people laugh with his great sense of humor, sharing his kind heart to those he loved, his friends, family. He had faults like everyone else, but he would be the first to jump in to help with what little he might have.
His sister reflected on the moments he would never experience, while his father spoke of the deep loss felt every day.
What it's done to me emotionally, when I go to bed, I want him back alive. I can picture him on fire calling for help. It's very hard. And for Asia, I forgive you.
Despite their sorrow, the family chose to extend forgiveness. Kiraz read an apology, saying she had not realized someone was inside the culvert, while her brother highlighted the importance of mental health awareness.
And look what happens. You guys need to realize mental health is real. Okay? Apologize to the family. I just love you. Sister.
Kiraz was convicted and received a sentence of 15 years to life. Both families left the courtroom with pain, but also with a message of healing and accountability. In December 2019, two armed men, Lamar Alexander and Ronnie Hill, attempted to rob a jewelry store in Coral Gables. One of the robbers entered disguised as a courier, and during the robbery, a store employee was injured before the owner fired back, forcing the suspects to flee.
He was carrying boxes, FedEx boxes, and he threw them to the floor. Then, I saw, and he pointed, and he fired. I was and this guy was like crazy, coming back and forth, walking and waiting for somebody to pick him up.
When their escape plan failed, they hijacked a UPS truck and forced its driver, Frank Ordonez, to continue the getaway. What followed was a tense police chase that stretched across multiple counties and ended on Miramar Parkway. The situation escalated into a large exchange of shots, leaving Ordonez, a bystander named Richard Cutshaw, and the two suspects. Investigators later counted many holes in the UPS truck, sparking serious questions about how officers handled the standoff.
Dozens and dozens of bullets were impacting inside the cabin. That metal portion, could that create a cloud of smoke?
It's possible.
Years later, in 2024, four Miami-Dade officers, Rodolfo Mirabal, Jose Mateo, Richard Santiesteban, and Leslie Lee, were indicted on manslaughter charges connected to the deaths of Ordonez and Cutshaw. In court hearings, prosecutors argued that officers had other options to resolve the crisis, while the defense maintained they acted in self-defense after being fired upon.
From what I remember, it was few, like maybe two or three.
It's really difficult when she's that far back, to determine the power. Is hard to smell that far.
In September 2025, a Brewer judge ruled that Officer Jose Mateo was protected under Florida's Stand Your Ground law, granting him immunity from prosecution. The state attorney's office has said it will appeal, while cases against the remaining officers are still moving forward. In early August 2025, Rebecca Harrow told police that her son Emmanuel had been kidnapped while she was in a Yucaipa parking lot. A large search effort was launched, but investigators soon noticed inconsistencies in her story. Within days, authorities began to suspect that the boy had never been taken and that something had happened before the report was made. Court documents later suggested Emmanuel may have died between August 5th and August 14th, nearly 9 days before his disappearance was announced. On August 22nd, Rebecca and her husband, Jake Harrow, were arrested and charged with murder and filing a false police report.
It's situations where there's torture or extreme cruelty or something of that nature that would qualify for the enhancement of the malice charge.
At their first court appearance, both arrived without attorneys, and their arraignment was postponed.
Initially, we received word that one or both would have private counsel. It appears that neither have private counsel. We cannot represent both.
On September 4th, they entered not guilty pleas to all charges. Prosecutors explained that evidence pointed to an ongoing pattern of mistreatment and that the kidnapping story had been fabricated.
I didn't get an opportunity to be a mom, but the minute I saw the minute I saw him, my gut, I just knew that something happened.
It pissed me off. I'm a mom of a 13-year-old, and I would never think of harming her in any type of way like these piece of did. My husband knows and everybody knows I have been night and day thinking about this child and praying that he is found.
Emmanuel's body has not been found, and searches continue across Riverside and San Bernardino counties. As the case moves through court, the focus remains on uncovering what happened to Emmanuel and seeking justice for him. In August 2024, Dakota Currington was riding his bike in Adrian, Michigan, when he was struck by a car. The driver, later identified as Felicia Madison, fled before police arrived, leaving Dakota with severe injuries that would change his life. He was rushed to Mott's Children's Hospital, where he spent months in recovery, showing only slow signs of progress.
He'll never be able to have a job. He'll never be able to get married. He'll never give me any grandchildren. He's starting to swallow a little bit more. He's moving his head more.
His family held on to hope, praying for his healing while also calling for accountability.
I'll put it this way, it's not something that God created. It had to be something that the devil has created in her. I try not to be so judgmental about it, but it's getting harder and harder and harder to, you hit my kid and you ran him over and then you kept going and then went for a year without even turning yourself in. That's a heartless person.
Sigh relief, but I have to relive it all over again.
That's the main thing is justice for Dakota. And Dakota didn't deserve anything that this person did to him.
Nearly a year later, in August 2025, U.S. Marshals located Madison hiding in Flint and arrested her. The next day, she was arraigned on a felony charge of failing to stop at the scene of an accident causing serious impairment.
I think he's more homesick right now, and the hospital, I think the same thing, that he's homesick. I couldn't be any more happy with my community. They have been fabulous for us the whole time through this whole ordeal.
For Dakota's parents, the arrest brought a measure of relief after months of uncertainty. His father spoke of small but meaningful improvements in Dakota's condition, while his mother emphasized their focus on bringing him home before the holidays. Supported by their community and grounded in faith, the family continues to balance the long road of Dakota's recovery with their pursuit of justice. In July 2023, 20-year-old Devin Grant lost his life outside the Harmony Apartments in Madison. Investigators later said the incident began earlier that day when Grant allegedly took cough syrup during a drug deal with Devontae Gafford. Prosecutors argued that Gafford and his acquaintance, Mark Parks Jr., later returned to the apartment complex, where shots were fired and Grant was fatally struck. Gafford was charged with first-degree intentional homicide and first-degree recklessly endangering safety, in addition to firearm possession as a felon. At his first trial in 2024, the jury convicted him only on the firearm charge, but could not agree on the most serious counts, leading to a mistrial. A retrial began in August 2025.
Priority one, sort of life safety and safety of human beings first, correct? Correct. And then the second thing is the preservation of the crime scene. That is correct. But in this particular instance, basically a vehicle drove right through the middle of a what was soon to be a homicide investigation, correct? That is correct.
Prosecutors described the act as planned, while the defense claimed Gafford was acting in self-defense after already being threatened. On August 29, 2025, a Dane County jury found him guilty on both major charges. His co-defendant, Parks, is set to face trial later in the year. In October 2021, Father Dennis "Denny" Dempsey, a 73-year-old priest serving communities in Burnsville, St. Paul, and Northfield, was riding his bicycle along County Road 42 in Rosemount when he was struck by a car. The driver was identified as Trajan Darrell Curry, who was operating a vehicle despite having a revoked license. Father Dempsey, remembered for decades of ministry and missionary work in Venezuela, at the scene, leaving parishioners and loved ones in shock. More than 2 years later, in January 2024, Curry pleaded guilty to criminal vehicular homicide, gross negligence. At sentencing in April 2024, during the hearing, family and friends of Father Dempsey described him as compassionate and devoted.
The victim's family has lost a father in Christ, a brother, someone's son. The victim, I heard, was a leader in this community who had compassion and mercy as his vocation, and he did it voluntarily.
I am sorry. This is not something I wanted. and I hope that they can forgive me and see that I'm honest and sincere.
Curry apologized directly to the family, expressing sorrow and a commitment to honor Dempsey's memory through his actions. The judge ordered him to serve 5 years of probation, with 30 days in jail or community service each year, along with 40 hours of additional service. In September 1989, 30-year-old Beverly Wyville of Canton Township disappeared shortly after dropping her son at school. Her car was later found still running with the driver's door open, and her body was discovered in Superior Township. For decades, the case remained unsolved despite repeated investigative efforts. Then, in January 2024, detectives used modern forensic genealogy to test DNA from Beverly's rape kit. The results pointed to Buster Robbins, a man from Almont. Investigators collected discarded items for comparison and searched his home, where they found a weapon consistent with the weapon used in the crime. Robbins was formally charged with rape and murder, finally reviving a case that had gone cold for more than 30 years.
I'm scared that he's going to get off. He's not going to have to pay for what he did. He took a wonderful woman out of this world. He took it all away from us, and he got to live. He's living his life, and she didn't.
As the case moved forward, a motion hearing in August 2025 became pivotal. Robbins' defense team argued that evidence from his phone, social media, and browsing history should be excluded, calling it irrelevant to an incident from decades ago.
They are trying to take away Mr. Robbins' freedom here. They want to go into his contacts. I don't see the reason for that in a case like this that's 36 years old.
Prosecutors countered that such information could reveal whether Robbins had revisited or reflected on the crime.
That the perpetrator could have reflected on the crime at any time since the crime occurred.
Yeah, that's true. In the movies, that's true.
It's not just in the movies that that people look up things about their own crimes. Also, movies probably get things from real life.
The judge ultimately ruled that only evidence directly tied to Beverly's case could be used, barring unrelated investigations in which Robbins was also a person of interest. With this ruling, the case now heads toward a final pretrial hearing in January 2026, followed by a scheduled trial in February 2026. In early July 2025, Cincinnati police were already familiar with 34-year-old Montanez Merriweather. On July 2nd, he was accused of possessing a weapon despite being a convicted felon, a federal charge that could carry up to 15 years if proven. Just weeks later, his name resurfaced in a case that drew national attention. On July 26th, a massive street fight broke out near 4th and Elm in downtown Cincinnati. Witnesses described chaos with dozens of people involved. Videos spread quickly online, showing violent clashes and a woman knocked unconscious. The incident shocked the city and brought heavy scrutiny from prosecutors. Within days, police began making arrests. Merriweather was among the first to be charged locally with felonious assault and aggravated rioting.
This is case number B25-04011-A, Montanez Merriweather. You've been indicted with 3 counts of felonious assault, 3 counts of assault, and 2 counts aggravated riot. Have you received a copy of your indictment?
He has, Your Honor. The plea is not guilty as to all counts.
Question I have for you at this point, has he been indicted federally on other charges?
Yes, Your Honor, on 1 weapons under disability that they decided to indict as of yesterday.
So are they going to pick him up, or
I haven't received
our case first?
I haven't received information as this happened late yesterday, but I still would like to address bond after consulting with another attorney that may be assisting with that. It would still be our expectation to ask for a release as that case is pending. Not to get too much into that, but there are other occupants in the vehicle that was involved with, so he may have a defense as to both.
Mr. Prosecutor, as the bond?
Your Honor, as the bond remained the same, I think it's reasonable.
What is the current bond?
I believe on Mr. Merriweather it is $500,000 with the indicia that bond be posted. The reason I think the bond is adequate, Your Honor, when these cases first came in through Room A, it was a very new situation. All the investigation had not been completed. And I'm going to repeat myself quite a bit here this morning.
Please do.
The grand jury, after hearing the probable cause of these cases, added several charges to each and every one of these defendants. For example, Mr. Merriweather came into Room A with a felonious assault and 1 count of assault. Through their investigation and our presentation to the grand jury, he's now been indicted on 3 counts of felonious assault, 3 misdemeanor assaults, and 2 counts of aggravated riot. I think the bond where it's set is appropriate. I would not ask to reduce the bond. I know he is a holder from the federal court system, and my great concern is if he posts a bond here, he will be taken into federal custody on a charge in federal cases. Your Honor is aware there's substantial mandatory time. It's a very real possibility that if he was taken into federal custody, we would never get Mr. Merriweather back into Hamilton County for a good number of years. I believe the bond in this particular case is sufficient and adequate, and I ask that you keep it the same.
A few questions for you. I know that the initial charges were brought about by a couple of videos on TikTok and Facebook. Does the state have actually more videos that they want to produce?
We do, Your Honor. Several videos have been received by Cincinnati Police Department. We have reviewed those. It is our plan within the next upcoming days, once discovery is filed by the numerous defense counsel, we will get them all copies of all videos. With their permission, I'll put together a court sequence that makes it make all sense. We'll turn that over appropriately. There are particular, I can think of 2 videos that have never been seen as far as I know through social media.
Are those videos from individuals or from stationary cameras?
Stationary cameras.
All right, they were in the area?
Yes, sir.
Okay. Did the alleged victims participate in grand jury process?
Yes, sir. I've personally been in contact with them. They are interested in going forward with these cases.
Are they local? Do they have local addresses?
Some do and some don't.
All right, but they will be here for the
Yes, sir.
trial?
Oh, yes, sir, 100%.
Because rumors are spreading that they are out of the country. That's not true?
No, sir. So just so everyone is aware, there was one person who was present. She is a citizen of Estonia, I believe. She is not any of the alleged victims from here. Shortly after this event, she made the decision to go back home. She was here for either a vacation or a short visit, but she is not a party to this matter whatsoever.
So all of the victims are here?
Yes, sir.
Local, ready to proceed?
And I've contacted them personally, and they are interested in going forward.
All right, thank you. Yes, ma'am.
As to bond, Your Honor, thank you. Judge, I will speak only, I'm going to be very careful about my representations based on what I have reviewed. Obviously, at this phase of the proceedings, it's arraignment. I have done numerous investigations and numerous interviews to make sure that everything I represent as far as our defense is as accurate as it can be. And I say that because this case, every time there's coverage of it, the prosecutor's statements about it, the comments used are the group, the 7, the riot. And I think as far as setting bond, it is very important for courts to look at an individual's conduct as it relates to what an appropriate bond is.
I agree.
And I say that because most of the videos shown where some of the conduct about stomping, kicking, heads, things like that, as far as what probably constitutes the felonious assault, was not done by Mr. Merriweather. As I indicated, probably 20 videos that I've watched numerous times, and I brought them to court to make sure my representations are correct, indicate him involved in a fight, a fist fight, and there's no debate about that. And the video shows when some of the individuals go on the ground, Mr. Merriweather walks away. And I do have footage of that with me today. And so I say all that, what we're here for, bond. We're not here to try the case. However, the bond of $500,000 is an incredibly high bond for that conduct specifically. And I know what he's indicted for, but what his conduct was, it will be our defense, is more consistent with an assault, maybe at worst an aggravated assault. So to come with objectivity before this court, I reviewed bonds set in 585 for similar offenses. All of them were $10,000 or less, and I have case names to present. And I say that also because the only charge of felonious assault that did not involve a firearm was a $50,000 bond at 10%. And that involved last week an individual that stabbed his father with a butcher knife, and that was $50,000 at 10. So now we're back to my client involved in fist fighting with a $500,000 bond. And we are asking this court to set a bond at $75,000 at 10%, much higher than the bonds that were set on other comparable felonious assaults. In addition to that, Your Honor, he's a father of 5, 3 of whom are biracial, because that's become a crux of this case, and I think that that's important to note. I've interviewed witnesses that will testify at a hearing and at trial that racial slurs were thrown against him and his family on this date. And so that comes back to, while we're not here to try the case, we're here to set a bond on him using fists. There is no allegation that he had a weapon. There's no video I've received that contact was made by a kick. And so I asked this court to set that bond because it's reasonable with the conduct in other cases in this courthouse. And if the media was not here and if the attention on this case was not here, I genuinely believe that a $75,000 bond for a fistfight would be absolutely reasonable to almost any jurist in this courthouse.
Except for the fact that he was out on bond when he committed this, or allegedly committed this offense, correct?
And, Your Honor, I
And
think
you know how I am, if you're out on
I agree
bond
with that,
and you
sir.
commit another offense.
I agree, sir.
Right.
And so I think with that offense, while we're not here to try it, I
Right.
did a careful job of reviewing that case prior to today's hearing to represent to this court that that involved a motor vehicle stop where other occupants were in the car.
Right.
And a firearm was found. He was the only person under disability. So it is important for sure, which is why I think $75,000 higher than the $10,000 bonds that I've seen across the board out of this courtroom.
Right.
We also would ask for EMD strict lockdown. That accomplishes a lot of the other goals of the purposes of setting bond, which I won't reiterate for the court. But I say all of that because I do think his conduct, I want to take this opportunity to make it very clear for everyone that is listening that his conduct, we do not believe rose to the level of felonious assault, and we ask that this court set the bond appropriately. Thank you.
Mr. Gunning.
Your Honor, I want to make the record very clear so everyone can listen. Throughout the short duration of this case, several defense counsels said that racial epithets were thrown at these people. That was 1 minute and 47 seconds into this brutal beatdown. Were the words said? Yes. Were they inappropriate? Absolutely. But these poor people were being assaulted, stomped, WWE-style elbow drops onto pavement. One woman was knocked out to the point that her head hit the pavement. We could be here on a homicide. For counsel to say that he is only responsible for misdemeanor assault is beyond the pale and against all the facts. She has not seen all the videos. Nobody has except myself and the officers involved here. Again, he was out on a bond for a weapons charge when he chose to get involved in this brutal beatdown. And again, so the word goes out, the word is clear. The horrible racial epithet was 1 minute and 47 seconds into these people being stomped, knocked unconscious. I don't want there to be any type of misunderstanding about this. This fight was started by these defendants. They followed them on the corner. They told them, quote, "You are at the wrong party. Get off this corner." And that's where these assaults started. I think the bond is appropriate. This man is already out on a felony charge. He has now been indicted federally, and I'm asking to keep the bond the same.
Tell me about his prior record. I didn't ask about that.
As indicated, he's got a pending weapon under disability, CCW.
How many prior felony convictions?
Let me see here, I'm sorry. Of course I would have that.
And Judge, while he's looking, and I understand that, I know the court is very patient, this will not be a back and forth.
No, take your time.
But I just want to make very clear as well, that again, the prosecutor's comments as it relates to other individuals' conduct, WWE stomping, we agree with, absolutely cross the line and is inappropriate. But I would, until it is Mr. Montanez Merriweather, WWE slammed, kicked someone in the head, that's what the court is here for him specifically, not this they, the fight. That's the whole problem with this whole case. And I brought the body camera footage, again, I have what I have, showing the individuals saying, smoking cigarettes, we don't need medical attention. So I appreciate Mr. Guinan's representations, but everyone's opinions about this case don't matter. What matters is what did he do that day for this court to set a bond? And that's what I'm asking for the representations to be made.
Well, we were hoping to have that compilation video here today so that everybody could see it and there would be no question as to what happened. Because again, people are only seeing whatever videos are posted out there on Facebook, so they're not reliable and they're not indicative of the entire situation.
We agree.
So again, Mr. Guinan indicated that he's the only one that's seen the entire start to finish of this incident.
Thank you for your patience on his record, Your Honor. In 2008, 2009, he was convicted of aggravated robbery, served a prison term of 7 years. That was his most recent conviction.
When was that?
2009, sir.
Okay.
Sentenced by Judge Nagel.
And served 7 years on that?
Yes, sir. Looks like it was 2 counts, concurrent time of 7 years.
All right, anything further?
Just, Your Honor, that he was not present at the bar that Mr. Guinan referenced. He was there with his family, and they were going to the food truck when this began. But I would also ask that the record reflect, if the video could be submitted to the court, and the court takes it under advisement, that's how confident we are in his actions that evening.
We will always review the bond.
I appreciate that.
Yeah.
Thank you, but that's all we have.
All right. Based on the fact of his prior record, the allegations, the fact that he has a federal folder, and he was out on bond when this occurred, the bond will remain the same.
His bond was set at $500,000 and kept at that level despite requests to lower it. Other suspects soon followed. Jermaine Matthews was identified as a main instigator. His bond raised to $270,000.
Jermaine Matthews, you've been indicted with 3 counts assault, 2 counts aggravated riot, and 3 counts felonious assault. Have you received a copy of your indictment?
He has.
How do you plead?
Not guilty.
State.
Mr. Fox made reference, and he's the first counsel to do so, about this infamous quote-unquote slap. I want to let the court be aware, at the time of this contact, GN had already been assaulted by 2 individuals, including this man here. He was hit from behind by Mr. Matthews and another individual. He was kicked from behind. So this assertion that they started this is completely not supported by any of the evidence that we have at this point. This man was wearing a red shirt. You can see him throughout the entire video. His conduct is violent. His conduct is more than mutual combat. He instigated, he performed, and participated throughout the entire beating, where 3 people suffered serious brain trauma. We blow off concussions, oh, it happens all the time. There's my time. But I want the court to be aware that this is the man that started it. This is another false narrative through the media, through the release of people's social media. That so-called slap was 47 seconds already into the assault. Already into GN being beaten for no reason by at least 2 individuals. The grand jury in their wisdom added a felonious assault. I think it's important this court consider that, and I'm asking you to set a bond on those new counts. Thank you.
All right, the monetary portion of the bond will remain the same. As far as the EMD lockdown, I'm going to give Mr. Matthews the opportunity to remain employed. So he will be allowed out only for employment purposes and also visit counsel and for court appearances.
Thank you, Your Honor.
Thank you.
Patrick Roseman, arrested in Georgia and extradited to Ohio, also had his bond held at $500,000. Dominique Kittle remained in custody pending a mental health review. 2 women charged in the case saw their bonds reduced.
Case number B25-04011-B to Kyra Vernon. You've been indicted with 3 counts assault, 2 counts aggravated riot, and 3 counts felonious assault. Have you received a copy of your indictment?
She has. The plea is not guilty.
Is beyond the pale. He also misstates the characterization of the conduct his client is accused of. And he has not had the opportunity to review all the videos. As I've told the court, I have. She is in direct physical contact with the victim on count 6 felonious assault and clearly on count 8 the felonious assault.
Count 6 is HR.
That's GN, Your Honor.
So not HR?
HR is count 8. She's also directly involved with HR.
Okay.
She strikes both of them several times. And let me be clear, this particular defendant interjected herself. She was not part of the original fight. She was down there and retrieved several items of property from one of the co-defendant's vehicles that was parked out front. And when the actual assault broke out, she was on the perimeter. As the fight progressed, she interjected herself. These people had no contact with her, yet she saw an opportunity. She jumped into the melee. She kicked. She stomped and had direct contact that caused concussions to these 2 particular victims. That are the facts. I'm not here to grandstand. I'm not here to state what I think this case is about. This case has nothing to do with race. This case has absolutely nothing to do with politics. I'm the most apolitical guy you'll find. This case is about what these people did. what these victims suffered. The bond is appropriate, and I ask you to keep it the same.
Judge, the last thing I'll say is this. I have a lot of respect for you, and that's not a personal indictment or accusation against you. Law enforcement, politicians, this case wouldn't be here but for race and politics. It's not an accusation against you, and I think everybody practicing law in this courtroom knows it. So I would ask that she have a bond that's based on the law and nothing else, and based on what she's accused with. He gave a description of what he believes she did based on his observation of the videos, which we have not seen. That's not before the court now. That's his opinion. It still doesn't change the nature and the circumstances of the crime. And what the legislator said, high bond if a weapon is involved. He didn't say a weapon was involved. And you still have her behaving in a manner that's consistent with misdemeanor assault by punching and kicking somebody, whether she did it on her own volition and it wasn't necessary. The claim is that she punched and she kicked someone. So a $200,000 bond for that alleged conduct is excessive and unconstitutional.
All right, the bond will be set at $25,000 at 10%.
DeKira Vernon's was cut from $200,000 to $25,000, while Aisha Devon's dropped from $300,000 to $25,000, each required to stay away from downtown. Gregory Wright, charged separately with aggravated robbery as well as riot, had his bond lowered from $100,000 to $50,000 under a 10% posting rule. By mid-August, a federal indictment had been added to Merriweather's local charges, tying back to the July 2nd firearm possession. Around the same time, Matthews faced unrelated federal drug charges after bonding out, adding to the drama surrounding the case. In September, 6 of the 7 suspects returned to court. Prosecutors emphasized that, if convicted on all counts, each could face decades in prison. Defense attorneys countered that the case was being overcharged and influenced by politics and race. The case remains ongoing, with trials expected to begin in the coming months. Elizabeth Betty Broderick married attorney Daniel T. Broderick III in the late 1960s. For years, she supported the household and raised their 2 daughters and 2 sons, while Dan built his career as a wealthy malpractice attorney in San Diego. By the mid-1980s, their marriage was under heavy strain. Betty later testified that Dan had become distant and secretive, especially about money. She described feeling shut out of decisions about their homes and future, even as they continued making offers on properties together. In 1985, she flew to New York for her father's birthday, leaving the daughters and sons with Dan. When she returned, she learned he had moved back into their Coral Reef house. He denied rumors about his young legal assistant, Linda Kolkina, but Betty remained suspicious. That same year, Betty discovered signs that the marriage was truly breaking down. The daughters and sons were sent away to camp without her involvement. She was placed on a monthly budget controlled by Dan and left in an empty house with little furniture. Then, in October 1985, she confronted him directly after hearing from family that he had taken Linda to a party. Dan finally admitted the affair. Betty said she felt manipulated, betrayed, and stripped of any security. Soon after, divorce papers arrived.
Find out that he tried to serve the divorce papers at any particular place?
Yes, I found a handwritten note in his very distinctive handwriting that on the date of the bishop's luncheon, it said the date and it said attempted service at the bishop's luncheon. And that was going to be the way he was going to serve me the very first papers of this entire divorce.
Okay, and
so it brought back all the memories of surprise and hardball, and it wasn't a nice thing to do.
Did you keep that note?
Yes, I did.
Okay. And at some point in time, did you give that note to anybody during your divorce trial?
I used it at the divorce trial as an illustration that this legal thing didn't...
Sustained. Did you give it to Mr. Berry? At some point in time, did Mr. Berry get a hold of it?
At the divorce trial, yes.
And have you ever seen that note since then?
No.
Now, did Dan ever talk to you about, was there any conversation about you being ill or sick?
Ever since 1983, those were the conversations, is that I was delusional and I was paranoid and I was imagining things and I was having a nervous breakdown and my wheels were coming off and I was crazy and I was sick. Yes, when he had the children and I wasn't living with them, he'd always tell them, oh, your poor mother's sick. Your mother's sick.
And did you, now after you received the divorce papers, did you have contact, did Dan contact you at any time in writing? On your birthday, did he contact you?
Yes, I received flowers with a card that said, I'm sorry you're not feeling well under the circumstances. Love, Dan. I think that's what it said.
And did you know where he was at that time?
No, I didn't.
How did that card make you feel?
I was furious because it was just like the night that he finally told me the truth. It's not that I'm crazy or that I'm sick, you know, I'm angry about things, and I'm feeling fine under the circumstances. I'm just angry about what he had done.
Did
But I'm not sick.
After you were told that there was going to be a divorce, did you contact anybody? Did you contact an attorney at some point in time in Los Angeles?
When I first got served with the divorce papers, that's the only thing I knew to do. I didn't know what else to do with them. So I started calling San Diego lawyers. It didn't occur to me to go to LA. I called about 8 lawyers right away, trying to hire a lawyer to defend myself. That's what I said. I was the defendant and he was the plaintiff, and I had to defend this action. And I needed a lawyer. And so I called all the lawyers, all the good divorce lawyers of reputation that I knew in San Diego County.
Were any of them willing to take the case?
No, in that one day, every single one of them said absolutely no. It would have nothing to do with the case because they knew Dan so well.
Okay. And did you eventually go to Los Angeles for a lawyer?
Only because a local attorney.
Objection, Your
It's sustained. Did you eventually go to a Los Angeles lawyer?
I was referred to one by a San Diego attorney, yes.
Okay. And why did you go? Why was the reason that you went to a Los Angeles attorney?
Because the well-known San Diego attorney advised me to quit trying, that no one in this town is going to help you, that you have to go out of town. And as a personal favor to me, although I've never met the woman, as a personal favor to me, she arranged this appointment with Mr. Jaffe.
Okay.
And he did it as a favor to her.
And where was Mr. Jaffe located?
In Los Angeles.
Okay. And did you reach an agreement with Mr. Jaffe?
He said he really didn't want to take the case. He didn't want to come to San Diego. It was inconvenient for him. He had more cases than he knew what to do with up there. But as a favor to this other attorney, he would try and represent me. And I signed an agreement. Should I keep going? I saw him the one day. I hired him. I signed the agreement. He told me not to worry.
Objection, non-responsive.
That's another question. Okay. What did he tell you? Did you talk to him about money and how he was going to get paid? You can answer that yes or no.
Yes.
And what did he tell you?
Objection, hearsay.
Overruled, you can answer that.
He told me that he would need a $10,000 retainer, that his fees on my half of the case alone would be over $100,000, and that I should not sign anything, and he would get the money, the $10,000 retainer, from Dan, because I didn't have any money, and he would get it from Dan, and the court would decide later whose half of the money it actually came out of. But since Dan controlled all the money, he had to get it from Dan. And he said that was pretty usual, and I shouldn't worry about anything.
Okay. Now, at this period of time, you knew Dan's family. You knew he had a brother, Larry. Is that correct?
Yes.
Did you know whether Dan or not had a retirement account at this time?
No. I mean, I knew in a very vague sense that he had a pension fund, is what he called it.
Okay. Did you know what was in the pension fund?
No idea.
Did you know whether he was transferring money from the pension fund in any time in 1985 to Larry?
No, I had no knowledge of the finances at all.
Okay. Did he ever talk to you prior to leaving in February of 1985 about giving large sums of money to Larry Broderick?
Yes.
Okay. What did he What did he tell you?
That his brother Larry had all these investments in mind, condos and historical buildings and duplexes and gold futures and bull semen. I mean, all kinds of investments, because that's Larry's field, is investments, I guess. And so Dan gave Larry humongous sums of money to be partners in investments.
Okay. Now, was
Over
this
the
all
years
in,
we were married.
Was this all in January of 1985, or was this over a period of time?
It was over a period of time.
Okay. Did you know what money had gone to Larry Broderick?
No.
Did you know whether your name was on any of that stuff?
Well, I assume since I never saw anything or never signed anything, that no, there's no way my name could have been on it. No, my name wasn't on anything.
Did you have control of any of those assets in 1985?
No.
Okay. Were you able to sell any of those assets to pay for whatever you wanted to, fixing the house, doing things in 1985?
I had no saleable assets at all. The car was even leased, so I couldn't even sell the car. And the house I was living in, the new house, had no equity at all. So even if I sold it, I wouldn't make any money. And it was in Dan's name as well as mine, so I couldn't go off and sell the house. So no, I had nothing I could sell.
Okay. Was there, at that point in time, the restraining order, was that also included not to talk to Dan Broderick?
I don't believe so.
Were you ever served with a restraining order that forbid you to talk to your children, that you were aware of?
No.
Okay. Did you try to, after he moved to the Cypress home in 1986, did you try to get some more of the furniture that he had?
Yes. After it became apparent that the furniture, or half of the furniture supposedly that he took, he had no interest in. He bought everything new in the Cypress home. Decorator, perfect, much fancier.
Was there a time, if you can just answer yes or no, was there a time that you tried to get the furniture that he had at Coral Reef and had moved over to Cypress?
Yes.
And what was the reason that you tried to get that furniture?
Because apparently he didn't want it. And I could have used it because I didn't want to spend money buying new stuff. And he bought new stuff. And it was in his garage piled up. And he didn't want it, so I might as well be able to get it back. But he said, no, I couldn't have it.
Now, you had a budget at that time, did you not?
The $9,000?
Yes.
Yeah.
Did you have any time when he wrote out the budget, did he include money in that to rebuild a house on Cowlitz?
No, my budget was clothes and food and rent and stuff, but there was no budget for lawyers or for remodeling or repairing a house or for refurnishing a house and buying towels and everything new. It was just a monthly budget that you'd use every month, but there was no provision in it for all these extraordinary things I had to invest in. Mainly the house and legal fees.
So there was no time where he gave a budget and gave you anything for legal fees?
Never.
Okay. Did you come to learn sometime in December, January of 1985 and 86, December of 85, January of 86, that he wanted to sell Coral Reef?
Yes.
And did you want to sell that home?
No, not at that time.
And why not?
Because it was the one asset in the whole world that had my name on half. So I knew he could cheat me out of anything else, but I didn't think he could cheat me out of that because my name was on half. And we are in a split up now, and we are in the process of a divorce, and I figured it was a bargaining table. And you know, I've got what I've got and you've got what you've got, and we're gonna talk about switching and stuff, and that was the only thing on my side of the bargaining table was half of that house. And I didn't want to give it up until I knew what I was trading it for.
Now, there was some testimony about that house being a depreciating asset. In other words, that house in La Jolla was going to, if it wasn't sold, was going to be going down in value. You were going to be losing money. Do you remember a conversation about that? That where someone
I don't think I was part of that conversation. I think that's what he told Mr. Jaffe that time.
Okay.
No, the house could have been rented for about 3 times what it cost to keep it going. It would have been a great investment to keep.
Now, at the time that they were talking to you about depreciating assets, did they talk about selling, for instance, a duplex in Dylann that was losing about twice its value a year?
No, there was no discussion of selling anything else, just that.
Did they talk to you about selling a historical building that was...
Objection, Your Honor. Ask some answers. Said there was no discussion of anything else.
Stay.
Betty claimed Dan used restraining orders and financial control to limit her access to her daughters and sons. She began keeping journals, recording her isolation and anger. Their divorce became one of San Diego's most public and acrimonious cases, with fights over property, custody, and money. On November 5th, 1989, Betty went to Dan's home in Marston Hills, where he was living with Linda. That morning, both Dan and Linda were shot and killed. Betty surrendered to police shortly after. She later said she had been overwhelmed and never planned the kills, insisting she couldn't remember pulling the trigger. Her first trial in 1990 ended in a hung jury. 10 jurors voted for murder, while 2 leaned toward manslaughter, citing her mental state. A second trial in 1991 brought a conviction. The prosecution argued the crimes were calculated, while the defense pointed to years of emotional abuse and pressure. In December 1991, Betty Broderick was found guilty of 2 counts of second-degree murder and sentenced to 32 years to life in prison. She has remained incarcerated ever since. Her parole requests have been denied, and she will not be eligible again until the 2030s. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.